section of civil rights and social justice. During the 2017-18 bar year, our goal is to rapidly respond to government action that may impact civil rights and civil liberties by offering free webinars, commentary, podcasts, social media posts, and other information from subject matter experts. We encourage you to go to the section's website, www.americanbar.org/CRSJ, and check out our Twitter at ABA_CRSJ for more news and information and replays of our great programming. We are thrilled to give you today our program entitled 5 Years Later, an update on VAWA 2013, Special Domestic Violence Criminal Jurisdiction over non-Indians. During the program, if you have any questions, please click on the questions box on your right-hand toolbar, and you can ask anything that you'd like, and our moderators will be reading the questions to ask during the program. Moderators today are John Dossett, the General Counsel of the National Congress of American Indians, and Virginia Davis, Senior Policy Advisor for the National Congress of American Indians. I'm going to turn it over to them, and thank you so much.
Thanks very much. This is John Dossett with NCAI. NCAI is a membership organization of Indian tribes across the country. We're very fortunate to work with tribes. We had the chance to work on the Violence Against Women Act and also to work with the tribes in implementing the new law. We'd like to really thank the American Bar Association for putting on the webinar today, but also for the ABA supported the law back when we were working on it in 2012 and 2013, and their support was really important. We love working with the smart lawyers at the American Bar Association. This law is really important for public safety on reservations across the country. I'd like to turn it over to Virginia Davis, who's going to give you just a little bit of background about it. So go ahead, Virginia.
Great, thanks, John. And I think, Liz, you're controlling my PowerPoint slides, right? So great, we can go to the first slide. Yeah, I'm really excited to be able to share a little bit with everybody about what 5 years of implementation of the Violence Against Women Act of 2013 has looked like. And I'm particularly excited for you to be able to hear from our later panelists after I do a quick overview of how we got here and we do some highlights of the past 5 years. You're going to hear from representatives from 4 of the tribes who have been implementing this law, and I'm really eager in particular for you to be able to hear from them. So you can go to the next slide. So, as John mentioned, when VAWA was reauthorized in 2013, it included a really groundbreaking and historic provision related to tribal jurisdiction. That's what we're going to be focused on today. When I talk about this, I often say, that the criminal jurisdiction, tribal jurisdiction provision in VAWA 2013 really, kind of changed the landscape for tribal jurisdiction in a fundamental way that's had a real impact for tribal communities. These pictures you're seeing right now show some of the really amazing Native women advocates and our allies who led the movement to get this passed. And then the bottom picture, is President Obama signing the bill into law 5 years ago today, which was really a historic moment for all of us. Okay, so I wanted to start by just kind of, for those of you that this may be a newer issue for, to paint a little bit of a picture for you about what the problem was, why the Violence Against Women Act is so important for tribal communities. There has been research for years that has documented the reality that Native women face in terms of violent victimization. The most recent studies that we have found that more than 4 in 5 American Indian Alaska Native women will experience violence in their lifetime. That's, over 84%. More than half of American Indian and Alaska Native women experience physical violence by intimate partners in their lifetime. So it's a very significant problem. Similarly, more than half of Native women are experiencing sexual violence in their lifetime. This NIJ study, where these statistics come from, found that 90% of those victims of physical violence by intimate partners report that they experienced violence at the hands of a non-Native perpetrator. So what we know is that Native women are 5 times as likely to have experienced physical violence by an interracial intimate partner than non-Hispanic white women. So the takeaways really from this slide are that the rates of violence experienced are incredibly high, and that the rates of interracial violence are much higher for Native women than they are for other women in the United States. Most typically, white women are assaulted by white men, Black women are assaulted by Black men, but for Native women, a huge number of the violent victimizations are being committed by someone of another race. And again, for those of you who may not work in Indian country, you might ask, well, why does that matter, right? What does it matter what the race of the perpetrator is when it comes to criminal accountability? But in Indian country, there is a very complicated jurisdictional scheme at play that left these victims, in particular the victims whose perpetrator was of a different race, who was not Indian, it left them without adequate protection from the criminal justice system. The case that really that creates that particular problem was U.S. v. Oliphant. It was decided in 1978. Actually, it was decided 30 years ago yesterday. And in that case, the U.S. Supreme Court held that tribal jurisdiction extended only to Indians in Indian country. So, Liz, actually, can you go ahead to the next slide? So I'm showing you this slide I'm definitely not going to walk through this flow chart, nor do I expect anybody to really digest it. But this is a flow chart that one attorney.
No, I'm kidding. Go ahead.
Yeah, right. And this slide I show only to drive home the fact that figuring out who has jurisdiction when a crime is committed in Indian country is incredibly complicated. Liz, if you go forward one more, it'll animate and circle something. One of the key questions that we ask is in this little box right here, which is asking if the wrongdoer, the person committing the crime, was Indian, and that's just a critical question for determining who has jurisdiction in Indian country. The general rule is that if the offender or the alleged offender is non-Indian, the tribe, the local government with authority over that land won't have jurisdiction to try that case. In most instances, the jurisdiction would reside with the federal government, although in some places the jurisdiction might reside with the state government. And that was really the problem that was leaving so many victims in Indian country of domestic violence who were being victimized at the hands of a non-Indian perpetrator without any access to justice. Their cases just weren't being prosecuted. Liz, you can go to the next slide. So this is a problem that we had known about for a long time. As early as 1994, there was a report from the Ninth Circuit Gender Bias Task Force talking about how the system of jurisdiction was leaving Indian women without adequate protection, and that a lot of these non-Native offenders were slipping through the cracks. My organization, the National Congress of American Indians, had a resolution on this topic in 2003. There was a report from Amnesty International in 2007 that really just kind of raised the profile of this issue in an incredibly helpful way and got it on the radar of both the media and members of Congress at a much higher level than it had been before. And in the wake of that report, we saw 20 congressional hearings between 2000 and 2012 focused on this issue and what to do. There was also, just a tremendous amount of support and advocacy on the part of the tribes and many of our allies, as John said, the ABA and others, calling for this injustice to be ended. And the remedy that everyone rallied around was to amend the Indian Civil Rights Act to reaffirm that tribes have authority on their lands to prosecute non-Indian crimes of domestic violence and violations of protective orders, which is basically what ended up happening in VAWA 2013. Liz, you can go to the next slide. So we tend to refer to it as Section 904 because that was the section of the bill that included the tribal jurisdiction provision that we're talking about today. And basically what it did was it affirmed tribal inherent authority to exercise criminal jurisdiction over non-Indians who commit 3 categories of conduct. So domestic violence, dating violence, or certain criminal violations of protection orders. So VAWA 2013 created a framework for tribes to start holding non-Indian batterers accountable for the first time since the Oliphant decision, but it did it in a very prescriptive way, and it is very narrowly drawn, and we'll be talking quite a bit about that on today's webinar. You can go to the next slide. So one thing to make clear about this is that everything that happened with the tribal jurisdiction provision in VAWA 2013, it's completely voluntary. So tribes can choose whether or not they want to exercise this authority, and where tribes choose to take on this responsibility, it doesn't change existing federal or state jurisdiction. So the rules otherwise are in place, and in many of these cases, you would have jurisdiction would reside both with the tribe and with the federal government, and they're often coordinating closely to figure out which one will move forward with the prosecution. Next slide. Okay, so as I said, one of the ways in which the statute is pretty narrowly drawn is that it's limited to those 3 categories of conduct: domestic violence, dating violence, and protection order violations. There are also a number of other ways in which the jurisdiction is limited. One, the crime must occur within Indian country, and Indian country is a legal term of art that that determines where the tribe's governmental authority lies. The victim of the crime must be a native person, and the defendant, the non-Indian defendant in the case, must have sufficient ties to the prosecuting tribal community. And those sufficient ties, the statute lays out as the defendant must reside in the tribe's Indian country, or work in the tribe's Indian country, or be in an intimate partner relationship with either a tribal member of the prosecuting tribe or with an Indian from another tribe who lives in the prosecuting tribe's territory. So all of those things have to be, all of these prongs have to be met for tribal jurisdiction to reside. So can you go to the next slide? The other thing that Congress did in VAWA 2013 is they laid out a host of due process requirements that tribes have to fulfill in order to exercise this jurisdiction. The tribal jurisdiction provision in VAWA 2013 was fairly heavily debated at the time. It was, there were a lot of supporters, and also folks that really had concerns about the idea of allowing tribes to creating this framework for tribes to prosecute non-Indians. And these due process requirements are set out in the statute and were a part of getting to the compromise to reaffirm the tribal authority in this way. So as you can see, the tribes are required to give effective assistance of counsel, indigent defense, law-trained judges. They have to make their criminal laws publicly available and maintain a record of the proceeding. It guarantees right to trial by an impartial jury, this including a jury that reflects a fair cross-section and doesn't exclude non-Indians. Mostly, these due process requirements basically mirror what is required in a state or federal proceeding, and many of them were also already required for tribes. A couple of things were new, though, in VAWA 2013, in particular the idea of including non-Indians on tribal juries. Well, you'll hear from the tribes, a number of tribes already did that, but some didn't, and they had to change their jury pools and their jury processes to be able to implement this jurisdiction over non-Indians. Okay, and I think at this point I'm turning it over to Liz to talk a little bit more about what implementation has looked like.
Yeah, so thank you very much, Virginia. So my name is Elizabeth Reese, and I'm a project attorney also at the National Congress of American Indians, where I work with tribes on who are specifically already implementing or thinking about implementing VAWA 2013 Special Domestic Violence Criminal Jurisdiction provision. So the first thing that happened after the law was passed was a pilot project. So tribes were able to apply to the U.S. Department of Justice and get approval to implement expanded criminal jurisdiction over non-Indians earlier than when the statute actually took general effect. So the first two tribes who were, or the first three tribes really who were able to do this were the Pascua Yaqui tribe in Arizona, and their chief prosecutor, O.J. Flores, is here and will speak to you shortly. The Confederate tribes of Umatilla in Oregon, and the Tulalip tribes of Washington. And they were actually able to implement VAWA for about a year before they were then joined by two more pilot project tribes, the Fort Peck tribe in Montana and the Sisseton-Wahpeton tribe in South Dakota. The great thing about the pilot project is it really let these groups of tribes become, early leaders in implementation, and also to figure out some of what the challenges would be. And so these tribes sort of remain leaders in VAWA implementation and really are tremendous resources for some of the other tribes who've implemented later to really sort of give advice and counsel. So the pilot project officially ended on March 7th, 2015. And at that point in time, any tribe that meets the statutory requirements that Virginia discussed earlier on that slide, the orange slide with mostly all of those due process requirements, can start bringing these cases against non-Indian batterers. So DOJ approval is no longer needed. That means that any tribe can really do this as long as they meet those federal requirements. So far, we are aware of 18 different tribes who are implementing this expanded jurisdiction. I won't read them all for you, but you can see them on this slide here. Of these 18 tribes, they're located in 11 different states across the country, and they really represent a tremendous geographic and demographic diversity of Indian country. Not only do they, greatly vary in size, but some of them are reservations that are relatively urban communities, while others are incredibly rural. So it's really demonstrated that the statute is something that is being used by tribes now that they have this expanded authority, and that it's also being used by lots of different types of tribes. So NCAI right now is finalizing a 5-year report that we've put together that is really sort of a synthesis of how these 18 tribes have been implementing the statute so far, and what the sort of top line takeaways are about parts of the statute that have been more challenging to implement, things that are narrow, as Virginia mentioned, parts of the jurisdiction are narrow, and so it has also revealed things that are particularly frustrating for effective public safety at these tribes. But right now, what I really want to share is just sort of the top line numbers that we have right now from the implementing tribes after 5 years of implementation. So far, there have been 142 arrests, which have led to 71 convictions, 70 of which were through guilty pleas and 1 was through a trial conviction. There have been 4 acquittals. There are 26 cases currently pending. There have been 14 referrals to federal cases, 19 declinations, 4 jury trials, 1 bench trial, and 21 dismissals. Those 142 arrests are of 127 different defendants, 90% of which are male. However, there have been 12 different women who have been arrested under the statute. There are in total 126 victims, 89% of which are female. However, there have also been 14 male victims. overall, even though, all tribes are required to give a right to a habeas corpus petition for all of these defendants to then go into federal court. However, there have been no habeas corpus petitions at all. Also, many of the cases involve children, whether or as witnesses or as victims. One thing about the statute, as Virginia mentioned, it only covers domestic and dating violence crimes. So it doesn't actually allow tribal police to arrest and then tribal prosecutors to prosecute cases where children are victims. So the common case that we hear about is you show up and you can do something about dad beating mom, but not dad beating the kids. However, that's something that, as you will hear from the tribe, there are also interesting potential things that the tribe can do under tribal protection orders, which technically would allow the tribe to, if it's a violation of a protection order protecting a child, allow them to do something about that, but that's rather complicated. And finally, also many of these cases involve drugs or alcohol, which is similarly outside this narrow scope of special domestic violence criminal jurisdiction. So now what I really want to do is actually turn it over to the representatives that we have from implementing tribes. So first, we have Jennifer Bergman from the Alabama-Coushatta tribe of Texas. Jennifer.
Good afternoon, everyone. I'm Jennifer Bergman. I'm from the eastern part of Texas. We're one of 3 tribes in Texas. And Texas is a public law 280 state. And so when you look at that jurisdictional chart earlier, that was all confusing and who has jurisdiction and trying to figure out how cases are prosecuted. In Texas, we have concurrent jurisdiction with the state. And so the state, the feds, and the tribe have concurrent criminal jurisdiction in every criminal case that we have. And so we have attempted to build a framework wherein we work within that system. And I guess a lot of tribes don't have that type of jurisdictional issues that we encounter. We have a greater ability, I think, because of the concurrent jurisdiction, to utilize VAWA in a way that most other tribes in different states are able to do that. I guess our first VAWA case was one of the cases involving a female where she was the offender. She was a non-tribal member, and her kids were enrolled members of the tribe. And so, I've described when I've spoken about this that the state has a very punitive system in nature where, they're more along the lines of making sure that the punishment is the greatest issue to them and not addressing the underlying concerns or what is the factors that have led us to the situation where we have a defendant who has committed family violence. And so, as was mentioned before, a lot of these cases involve drugs and alcohol, and all of the cases that have come to us have all involved drugs and alcohol. And so the case that the initial one that we filed involved a female, and there were drugs involved, and there were a number of other things. And so we have the ability, I guess, to utilize the fact that we could dip a defendant off to the state system and kind of use that to kind of, I guess, get the outcome that we want, which is most beneficial for the tribe and the children of the defendant. And so we got our defendant help. We got her into rehab, and so we have a greater ability and latitude in being able to help these defendants. And so I think that's one of the good things about our ability to prosecute VAWA. And because I guess they know that these crimes are not going to go unaddressed because they occur on the reservation.
Great, thank you, Jennifer. So up next is Chief Judge Stacy, if you want to talk about implementation at Fort Peck. I don't think we can hear you.
Okay, can you hear me?
Yeah.
Yeah.
Sorry, I had it muted. Fort Peck implemented March 6, 2015, and one of the interesting things is at the time the chief judge that we had, he was not a law-trained judge. And I believe in the handout that's going to come out from NTI, or the report states at the time we had a special judge, a lawyer judge, and she was brought on after we actually got authorization to move forward to exercise the VAWA jurisdiction. So the chief judge at the time was not law trained, but he did have certificates from the National Judicial College, and he had years of experience on a bench and was consistently hearing criminal trials. So we qualified under that. And I know there's been discussion, what is considered law trained. So that was one of the things that Fort Peck made it through and got accepted on the pilot program with. And we have the issues, that we've run into are with, we haven't had any jury issues. Our jury actually has gone pretty good because we utilize the county records, the voting, and the county was more than willing to give it to us, and we told them why. And the interesting thing is today is actually our first jury trial, and they're on break right now deliberating. So we will see what will happen with our first VAWA jury trial. And the other interesting thing is all of the jurors are non-Indian. So we were worried about who would come, who wouldn't come, and they all showed up. So got through that process, and hopefully within the next half an hour, maybe by the time we finish this, we'll find out what the outcome is.
This is great. I'm on the edge of my seat here.
Yeah, I'm really, really nervous about it just because our jury trials, we have jury trials all the time, but they're always, with tribal members that come in here. What we had done with our code, though, is we opened up our juries were limited to tribal members only, and we did open it up to any Indian. So Indians can sit on a jury, and then we opened it up to non-Indians. Our non-Indians only sit on the VAWA jury. So we have Indians, no matter where you're enrolled, sitting on any criminal case. And but one of the issues that we had at the beginning was the attorney, because we're located in such a rural area, and so getting somebody to come here was pretty hard for one. And we've actually had really good outcome with that. We've had 2 long-term public defenders. We have 2 attorney prosecutors, and the other thing that happened in between all of this was the tribe decided that they wanted to elect judges. So this 2000, we came on in 15. So 2015, shortly after we had implemented in March, in November, the tribe did the election of the judges. So there was no requirement to be necessarily law trained, which was a little worrisome because we were wondering, well, what's going to happen if they elect somebody who isn't qualified under our VAWA? But I was elected to the chief judge position, and then we had 3 other associate judges come in, and we have at least 2 of those associate judges that actually would qualify under our what we had committed to with our VAWA jurisdiction. So we're still in a good position, and we the other thing that we have going for us is we actually opened up a new jail shortly before we had implemented VAWA, and it's about a 108-bed facility. It is a tribal jail, and so we have the capacity and we have room to take care of the prisoners and to hold them here. And we also had implemented VAWA, so we do have the enhancement portion of it that's available to us as well. We haven't, we've had habeas filings within the tribal court portion, but none of them have gone beyond that. And looking at the stats that that we've all seen from all of the tribes, the main problems that we have is how do we deal with the victims that are children? And we've had a lot of those come through here, and how can we we can provide services to the families and to the victims, but there's nothing else we can do except maybe give it to the feds and see if they want to do anything with it. But as it stands right now, we've never had an issue with holding anybody in our tribal jail. The only problem we've run into is medical expenses. And, we've been trying to do workarounds with that and, get MOUs in place, find out the Medicaid issue, because most of them that do come in here have some type of assistance with healthcare. And the area we're in, we have Indian Health Service and we have one hospital. So getting care to those that need it is one of the hurdles that we're still working with right now. And as you can see, we do have our code online. It's at fptc.org. And we also have other things in there. If other tribes are wanting some resources, you can go to that. You'll see our complete code. You'll see some of the forms that we use. We have some generic fillable forms in there that are available. And I would just like to encourage everybody, if you're looking for code revisions, there's a lot of assistance out there. There's a lot of technical assistance. There's a lot of grants available. We actually did it ourselves, so we didn't have a cost to us for that. We had in-house attorneys, and we had people here that were able to work on that for us. And I think that's about all I have.
Great. Thank you so much, Chief Judge Stacy. All right, so up next, it would be great if we could hear from the judge at the Sioux Ste. Marie tribe of Chippewa Indians.
Sure. Hi, I'm Jocelyn Fabry. I'm the judge for the Sioux Ste. Marie tribe of Chippewa Indians. We are located in northern Michigan, way up north, and we have reservation property throughout Michigan's Upper Peninsula, really in a checkerboard fashion. So we have a large membership population, but not a large land base. Our tribe adopted the provisions of VAWA in December 2016. So we weren't a pilot tribe, but we've been up and running now a little over a year. When we were presenting the draft codes to our council, we anticipated or estimated we'd have about 3 cases a year. In about 16 months, we've had 10 cases. We had our first case filed on December 30th of 2016. When we implemented, we were fortunate in that we already had a lot of the infrastructure in place. We were already utilizing Indigent Defense Council. We were already recording proceedings, had our laws publicly available. The one thing that we did not have that we needed to put in place were non-natives on our jury panel. We are using team members, tribal employees for that purpose. We have had one jury trial that ended in an acquittal, but all of our non-native jurors showed up, so we haven't had any issues with accountability for non-native jurors. That first case that was filed back on December 30th, that person actually just was our first non-native defendant to complete our domestic violence court. And what's interesting about that case, so we've had a good working relationship for the most part with our federal prosecutors in the Western District of Michigan. There have been some declinations. We knew that was a gap that needed to be filled. But that first case that we had was one that the federal prosecutors actually wanted to take. Our tribal prosecutor fought a little bit with them for the case to remain in tribal court. The reason for that being is the federal court is located about 3 hours from Sault Ste. Marie, where the incident took place. I could look out my window here and see the residence where that took place. It was a married couple, tribal children in common. We knew after any federal sentence that he might serve that he was going to come right back to the reservation, that this family was going to reunify. And so it really made more sense for the family, for the tribe, for that case to remain in tribal court. And so, like I said, I'm happy to say he just completed our domestic violence court program with all of the rehabilitative services that he completed. The family is together. And so that we certainly count as a real success. One hurdle that we have, or one barrier, one huge flaw in the system, again, relates to children. For us, we had a case within the last 6 months or so, where the allegations were CSC, inappropriate touching by the non-native male to his girlfriend's daughter, who he resided with. Case was filed in tribal court. Although it would have met our tribal code definition of domestic violence, didn't meet the requirements of VAWA. So the case had to be dismissed. A PPO wasn't entered because mom didn't show up for court. Some 4 or 6 months later, this individual went on to allegedly reach out to another young tribal member, 14 years old, online, took her off the reservation to a hotel where he engaged in criminal sexual conduct against her over the course of a day. That case is now pending in state court. And so, that just shows the real ramifications of our tribal court not being able to address his previous behavior before it led to the alleged continued victimization of another young tribal child. So, and I know that's something that everyone continues to work on, so.
Thanks so much. That was one of the questions was, can we predict when the legislation is going to pass? It's very tough to predict when Congress is going to pass any legislation, but it's up to all of us to put the pressure on Congress to get the job done.
Absolutely.
All right. Thank you so much. All right, now if we can hear from OJ, who is the Chief Prosecutor at the Pascua Yaqui tribe, which currently is the implementing tribe with the highest number of arrests.
Yeah, thanks, Elizabeth. Can you guys hear me?
Yes, OJ.
Yep.
Okay. Yeah, hi. Hello, everybody. My name is OJ Flores. I'm the Chief Prosecutor for the Pascua Yaqui tribe, and like Elizabeth mentioned, we've been pretty busy since VAWA implementation. We began exercising jurisdiction back on February 20th of 2014, and I believe it was within the first couple hours that we actually started exercising that we got our very first arrest from the actual implementation. We were the first tribe to get a conviction under VAWA by way of a plea agreement on July 2nd, 2014. And since then, we've been pretty busy in terms of investigations and convictions as far as those go. We've had a total of 53 investigations, and the reason that we keep track of investigations is because, as Virginia mentioned, since we didn't have this jurisdiction, or at least the jurisdiction was stripped away with the Oliphant case, we look at it as an opportunity to make sure that we, along with our along with our court system, that we made sure to include any sort of educational or improvement methods of our law enforcement to investigate these types of cases. And I'll share with you a case a little bit later on about why that's going to be important, because there's some very unique things involved in our law enforcement investigating these types of cases. But of those 53 investigations, we've had a total of 40 different defendants, and they've ranged in ages of 18 to 57. We've had a total of 35 of those defendants being male, 5 of them being female, and they break down into 27 of those defendants having been Hispanic, 6 African American, 4 Caucasian, 2 Mexican nationals, and 1 Asian. And of those 40 charged cases, we've now had 20 convictions by way of various different forms of plea agreements, 13 different variations of dismissals for prosecutorial discretion reasons, evidentiary reasons, some of the inherent difficulties that are present in prosecuting domestic violence cases. And the reason why some of those cases have been dismissed or declined presents one of the barriers that I'll talk about a little bit later as well. We've had 3 jury trials. 2 of those jury trials, we were not able to secure convictions for different variations of kind of nuanced facets involved in VAWA. One of the first jury trial that resulted in an acquittal was due to the limitations on whether or not somebody was in a romantic or intimate partner relationship. And that was because the case was a same-sex case, and that was the very first jury trial to have occurred under VAWA jurisdiction. And it certainly caused people to think about it in a way that probably wasn't originally intended or originally anticipated to be the case that kind of teases out some of the nuances in the law. But at the end of the day, our law enforcement, who did a really fantastic job in investigating the case, as well as our prosecuting the case and presenting it toward a jury, found that there wasn't sufficient evidence of a relationship that was presented to them in order to find one of the jurisdictional elements, that being of an intimate partner relationship. And that was the defense, was that these 2 individuals were not engaged in a romantic or intimate partner relationship, and it was successful. And the reason why it sounds relatively simple to prove, but at the end of the trial, when we were when we had an opportunity to speak with the jurors, they shared what they thought the evidence of being an intimate partner would be. And those were things that law enforcement aren't necessarily trained routinely to ask for. And this is one of those areas where VAWA is slightly different for Indian country law enforcement. And everybody had a different answer on what they would expect to hear as indicators of being in a romantic relationship, particularly in a same-sex case. But that being, the case, everybody wanted to hear it spanned from hearing about more details of a sexual relationship all the way to, Facebook posts and hand-holding. And those are types of things that law enforcement don't routinely do. Those are types of questions that law enforcement aren't trained to ask for obvious reasons. And so that presents some interesting kind of components to investigating VAWA cases. We had another one of our other jury trials resulted in an acquittal due to some legal discussion and analysis, similar to what federal courts use in terms of the U.S. Attorney's Office having jurisdiction in Indian country, and that being an element of whether or not Indian status or on the Indian reservation. That being in the realm of the federal courts, we had an issue involved the jury instruction form, whether or not the tribe had to affirmatively prove that the defendant was in fact a non-Indian. And that's been an issue that, again, a relatively simple question, but practically very difficult to prove in court. Essentially, we'd have to get affidavits or letters or certified court documents or enrollment documents from every single tribe across the country. And that would be something very difficult to prove, is proven a negative. But nonetheless, that's working its way through our Court of Appeals process. And so we'll keep people posted as that moves forward. And our most recent jury trial resulted in a conviction of a defendant that, like many of the other tribes, we've provided this suspect with a tremendous amount of resources and provided a lot of rehabilitative efforts. In fact, this individual had come through our courts one time prior, in which case we were trying to resolve probation matters and a subsequent VAWA case. And ultimately, that defendant was found guilty of committing acts of domestic violence against his partner in a fit of rage, destroying many things and causing a lot of fear in our tribal member victim, and ultimately was sentenced to 100 days in a detention facility. So that's been our experiences in the jury trial process. We have mixed juries, not only in the criminal in the criminal side of the court, but we do mixed juries for every single one of our jury trials. We have not had any issues involved with the cross-section of our community. None of those issues have been raised. We've been doing it for quite some time now, and we've got a really well, a really great defense bar out here who does a great job of defending their clients in court and ensuring and holding the prosecutor's office to the standards and certainly making sure that all the due process requirements are completely complied with. In fact, we have another defense attorney who practiced out here who actually, through sort of the kind of catch-all provision in VAWA that says any U.S. protections that are necessary during the process of a VAWA case will be applicable, filed an AIC motion, which is a fairly common criminal defense attorney motion to request the court to provide indigent defense funds for psychological or mental health examinations. And that was a learning moment for us out here, where we then had to address that issue in terms of our court providing indigent defense resources to ensure that they had the ability to fairly put on the defense, put on their own defense in our tribal court. And so that was a really a key learning moment for us. And some other kind of nuanced type things that we've experienced and that have really been a tremendous asset to our criminal justice system, as well as providing greater safety provisions for our community membership, is in the past, people would be able to essentially go off the reservation and flee from our jurisdiction and not be able to be brought back. Over the last few years, we've actually exercised a state statute and provision that allows us to extradite folks back to the reservation to answer for tribal court warrants. And we've been able to do that on at least 2 of our defendants and bring them back and answer to our tribal court. Certainly, we've had a lot of different experiences throughout the last few years here, and it wouldn't be possible without this jurisdictional expansion. Certainly, we've had issues where cases we had the unfortunate circumstance where we weren't able to charge for the children being present and at least 32 kids being present in some of our cases. And that was something, we look forward to helping get resolved in the future and certainly address that issue and provide as much safety as we can for our community members. And there's plenty of other experiences that we've had along the way. I know we've got the report that'll be available, and I don't want to take up too much of the time, so I think that's a pretty good snapshot of what's been going on at Pascua Yaqui Tribe, and we've been very fortunate to have great relationships with some of the folks that are presenting here today, and we're really happy to be a part of this movement. So thank you.
Thanks so much, OJ. That was great. Well, Liz, are we to the questions section of our agenda today?
Not quite yet. Now I'm just going to briefly go over some of the findings from the 5-year report that sort of synthesize what a lot of the representatives here today from the tribe have been talking about how implementation has been going so far. So in NCAI's 5-year report, which we will send out to all the attendees if we can, once it becomes actually finalized, hopefully in the next few weeks or so, we've really made 4 sort of core findings. The first is that tribes have actually been using the provisions of VAWA 2013 to exercise special domestic violence criminal jurisdiction in a way that is really helping with public safety in their communities. So some things illustrating that. So first, as Virginia mentioned, when the law was before Congress, there was a lot of questions about whether or not these statistics about non-Indians committing domestic violence against Indian persons was really a problem. Even though the statistics said one thing, there were certainly people who still doubted whether or not this was really happening and at the rates that everyone was talking about. And I think the prosecutions so far, particularly the tribes who have, had the number of cases actually exceed their expectations, like Sioux St. Marie was discussing, has really confirmed that this really is a problem, and that giving tribes or reaffirming tribal inherent jurisdiction over these cases is a solution that is really helping ensure public safety. Another thing that is clear is that actually giving tribes the ability to prosecute these cases is really ending a pattern of domestic violence for a lot of people, wherein also, because these cases weren't being prosecuted, batterers really felt like no one could touch them. So from a lot of the tribes, we hear that the people that they are now arresting, once they have exercised expanded criminal jurisdiction, these are people that tribal police were coming into contact with routinely, where the cops were showing up over and over again, but they weren't actually able to arrest or do anything about it. So just from the number of prior police contacts that the eventual SDVCJ defendants have, it's very clear that the law is touching people who were previously fairly untouchable. Also, it's been clear that a lot of the defendants are people who have criminal records or outstanding warrants from other jurisdictions as well. So these are often individuals who are, in many different ways dangerous to the to Indian communities. And so it's been really vital that tribes have been able to do something about that. In fact, so at least 45 defendants have criminal records, which is in total of the tribes who track that statistic, it's 66% of all defendants. And as I mentioned, there have been a tremendous amount of prior police contacts. Not all tribes track this data point. However, of the handful of the 18 tribes that do, they've tracked over 378 different times that their tribal police have come into contact with these people that they've eventually prosecuted under expanded VAWA jurisdiction. So the next major finding is that tribal courts uphold the rights of defendants and are committed to their rehabilitation. So similarly, when the law was being considered, there was also a concern about whether or not non-natives would get a fair day in court from Indian tribes. Advocates like NCAI were, vehemently saying that, of course, non-natives would get a fair trial in tribal courts, but actual implementation has, only gone to prove that, we were right in what we knew, which is that tribal courts are, houses of justice, just like any other, and committed to ensuring that justice is served. So from the case outcomes, the fact that there have been acquittals and declinations really demonstrates that tribes are only prosecuting those cases which actually warrant prosecution, that they're taking implementation seriously, and that, if someone needs to be acquitted for some reason or another, they really are going through all of those steps. Like OJ talked about, even if on technical jurisdiction issues, tribes are really committed to getting it right. And so I think that really demonstrates a fundamental commitment and also a fundamental fairness for these non-Indian offenders. Also, as Jennifer Bergman from Alabama-Coushatta talked about earlier, tribes are really invested in ensuring that defendants get help as well as punishment. So if you think about tribal courts, they're very much local courts. And so in many cases, these non-Indian offenders are part of the community in one way or another. They might be the parent of tribally enrolled children or have lived on the reservation for a long time. And, it's clear that a lot of the tribes are really committed to ensuring that those folks go to various support programs as part of their sentences, and that they can really work with those offenders in an individualized manner to ensure that they also get help so that they don't reoffend. So in total, actually, we approximate that about 51%, so over half of defendants are sent to rehab, battery, or intervention, or some other form of support program as a part of their sentence from tribal court. The third major finding is that implementation has revealed serious limitations in the law. So as discussed by, I think, pretty much all of the folks here who are from implementing tribes, there are lots of crimes against children, and those largely go unpunished since the tribe can't actually include those crimes as part of their charges against SDVCJ defendants. And, you know, as discussed by those tribal members, there are real life consequences to tribes not being able to do anything about these cases, or to having to wait for the state or the feds to do something about it. Similarly, lots of crimes involve drugs or alcohol, and that those cases also fall outside the scope of SDVCJ jurisdiction. Another thing to point out about that is that in a lot of cases, what that means is, since prosecutors don't have those additional charges to sort of bargain with, it can really limit the ability of prosecutors to negotiate appropriate plea deals, and, you know, could systemically result in SDVCJ defendants not receiving, you know, appropriate sentences that include the full scope of the crimes that they've committed. Similarly, crimes that occur within the criminal justice system are also unpunished. The type of case that sticks out here is basically an assault on a police officer. SDVCJ, as Virginia mentioned, is very narrow. It only involves domestic or dating violence that also includes an intimate partner relationship. And so there's no intimate partner relationship between the arresting officer and the offender that they're showing up to arrest. And so if an assault occurs, that assault, though integrally tied up in the crime that they're showing up to arrest him for, isn't actually covered under special domestic violence criminal jurisdiction. And so that would technically need to be a separate case that would need to go either federal or state, depending on, you know, the various factors that the flowchart Virginia showed earlier would dictate. Also, after a Supreme Court case that had some dicta about the definition of domestic violence, there was initial confusion about sort of the scope of that term under federal law, and how that term in federal law would then translate to tribal law, and tribes' ability to make those arrests under special domestic violence criminal jurisdiction. I won't take up more time on that one because it's a very technical legal issue, but it did lead to a fair amount of confusion. Also, very importantly, implementing special domestic violence criminal jurisdiction is prohibitively expensive for some tribes. So, as discussed by, I believe, Chief Judge Smith earlier, detention actually costs money. Tribes, and then in addition to the direct cost of actually paying to house offenders in jail, there's also issues like healthcare that, you know, for those of you who may not be very familiar with some of how this works in Indian country, the Federal Indian Health Service provides healthcare to Indians who live on reservations if they have a facility that's nearby. However, these non-Indian offenders can't necessarily go to Indian Health Service, or it's unclear whether or not they could go to Indian Health Service. So at least for some of the early tribes who've implemented, they've had to cover healthcare sort of directly out of pocket, or arrange for some kind of an insurance, and that's time-consuming and expensive. And so many tribes, sort of concerned about what those costs would be, have actually said, you know, that that's the reason why they've chosen not to actually exercise expanded jurisdiction. And similarly, just other, in addition to the cost issues about whether or not and where defendants can actually be housed, can they be sent to BIA facilities, have also been very challenging for tribes. And then finally, special domestic violence criminal jurisdiction is also jurisdictionally very complex. So as OJ was talking about with the trial that they had where non-Indian status had to actually turn into a jury instruction, exactly when a tribe has jurisdiction over a non-Indian offender can involve some factual questions such as non-Indian status or such as the intimate partner relationship that aren't traditionally things that courts are used to proving at all, let alone potentially in an early stage of the case where the court is actually figuring out where they have jurisdiction. So as a result of that, there's also been a lot of conversation across the implementing tribes about what it is, about how to deal with these jurisdictional complexities, when to deal with these jurisdictional complexities. And so certainly I think in that realm also, you know, further federal clarity would also be helpful. So that's all I'm going to share about the report. It will be coming out soon and it will certainly be available on our website. Also, if you have, if you would like to look at any other resources in addition to those which were provided as handouts to this presentation, you can go to our website, which is on this slide here, NCAI /tribal VAWA, and we've also collected a lot of resources, everything from code development checklists to materials put out by the tribes themselves to really help not only if you want to learn about the issue, but if you yourself are from a tribe that might be interested in implementing expanded jurisdiction, we really want to be a resource for that as well. So now I'm going to turn it back over to our moderators because now it is time for questions.
Thanks very much, Liz. All right, I don't know if we're getting close to the end. I've been trying to answer the questions that have been coming over the wire. I don't know if anybody would like to raise their hand. Maybe Liz, you can help make sure I'm seeing the hands as they're raised, if they are, and see if we got any questions here. The one question I noticed in writing that we haven't really answered was, it was a question basically whether, with so many of these cases involving substance abuse, should the funds be better spent on treatment rather than a criminal punishment? And I guess I wondered, you know, maybe Virginia, if that was something you had some thoughts on. Do we still have Virginia?
You know, I'd actually, yeah, I'm here if you can hear me. I'd actually be really interested to hear what our tribal reps have to say about that too. I mean, you know, I think in general, you know, it's dealing with the underlying causes and making sure that that there is healing for both the victims and the batterers is the best practice, right? And making sure that violence doesn't recur. But I'd be really curious to hear from our tribal panelists any thoughts they may have about that.
Well, I'll pipe up on this one. This is Judge Fabry from Sioux Tribe. So treatment, absolutely. So any offender that, you know, comes before the tribal court, we try to, again, like Virginia was saying, reach the, you know, root cause and not just the behavior. Of course, that's part of it too. I know there were a couple of questions about our domestic violence court program, and that's one of the things that we try to address, you know, get a good assessment on all of these folks, not just their criminogenic needs, but their, you know, if they have any behavioral health needs. And that, you know, obviously, I don't think we're any different than any other tribal court that sees the vast majority of their criminal cases involving substance abuse issues. and trying to, direct people to treatment.
And John, you did have a specific question for Judge Smith that we didn't answer. Would you like me to read that for Judge Smith?
That would be terrific.
Okay, great. So Judge Smith, we had someone who wrote in asking, how did you determine your non-Indian jury pool? Did you get non-Indian employees, all non-Indians on the reservation, or all non-Indian persons in the surrounding community? So what's the composition of the jury pool? Judge Smith, you might be muted. Let me see if we can.
Thank you, Denise. Okay, sorry. So our reservation covers 4 counties, but a majority of our reservation is on Roosevelt County, and the county seat for the state, Wolf Point, sits on the reservation. So we took the voting. The county provided us with all of the registered voters for Roosevelt County, and that's how we determined our non-Indian jury pool. And so we sent them out, and we put out a questionnaire along with them. It is similar to maybe a questionnaire that you would see in federal court. And so we found out, of course, some of them, they were registered to vote here, but they were living in, other areas. And they would write back and say, I'll come if I have to, but, I don't live there anymore. So we narrowed down, who was available and who wasn't. But there was approximately, I'd say I think there was maybe 5,000 registered voters from the county that they had given us, back in 2015. And they haven't had an issue, giving it to us on an annual basis, sharing the information with us. And then from there, we took it, we put them in a database and just randomly selected them with a computer app.
Thanks very much. So I was going to follow up with a question that came up on the screen, and I thought maybe this would be for OJ. It was a good question for you. Are the federal partners, like the U.S. attorneys and the FBI, are they generally supportive of tribes implementing? And I thought you had a lot of experience with that, but also working with like the state government in Arizona as well. So any thoughts on that one, OJ?
Sure. Yeah, we have a tremendously positive relationship with our U.S. attorney, and that's been a real kind of paradigm shift over the last few years, and we've had a lot of close collaborative works with him. I can recall when we were when we had applied for our application to the Department of Justice to start exercising and being part of the pilot tribe. The current acting U.S. attorney here in Arizona, Elizabeth Strange, was actually out here and gave some positive feedback in regard to our application for pilot status. And the FBI has, our law, we have a tribally operated law enforcement department, and they have, they're cross-deputized to be federal officers and state officers, so they can bring people into tribal court, state court, federal court, and they work really closely with the FBI in terms of all of our investigations. And because of the positive relationship that we have, we've actually kind of expanded our monthly. We have a monthly MDT meeting, a multidisciplinary team meeting with the U.S. Attorney's Office and the FBI there, where we actually have an opportunity to staff and discuss any sort of significant sort of criminal investigations that may involve the U.S. Attorney's Office, which has specifically included some of our VAWA cases, where we've made some referrals for some of the folks that we've convicted here in tribal court, and then picked up a third or subsequent arrest, and we referred it to the U.S. Attorney's Office to be charged and convicted under the habitual offender, the domestic violence habitual offender statute, and they received and they got a conviction of that guy as well. So we work really close with them in the day-to-day operations, as well as kind of getting implemented with VAWA. And with the state, our state relationships are just as positive, although we don't have as much face-to-face interaction with them. We do have the ability, like I mentioned, we we extradited 2 folks back to the Pascua Yaqui Tribal Court from the local counties, Pima County here in Arizona, which is the Tucson area of southern Arizona. And we filed the extradition paperwork much like we would in any other instance. And it went through without a hitch and without any sort of second looking. And a lot of that has to do with us and having a positive relationship with them.
Thanks so much, OJ. All right, well, here's another question. This question comes from a former tribal judge. As a former tribal judge who has seen how difficult it is to get defendants to comply with their DV treatment, how would you punish someone, a non-Indian offender, who is not complying with their mandated treatment? That's an interesting question. Maybe we should turn to one of our judges to talk about what do you do when the offenders aren't complying with their treatment?
Well, I mean, for us, our non-natives that have been convicted to this point have also participated in our domestic violence court program along with our native offenders, and so we really treat them the same. The nice part about that program is they're coming before the court every 2 weeks, so we usually have a pretty good pulse on how they're doing. If they're not complying with their counseling or the men's education group, we know that pretty quickly and can address it pretty quickly through all the typical means of, anything from giving a warning to, random checks to, addressing barriers to the completing treatment, giving them a ride, up to and including jail for violations. So we really, we treat them just the same as we would any other offender who's not complying with probation.
Thanks so much, Judge. All right, I've got another question for Oscar Flores. OJ, in what ways has the same-sex partnership case informed your training of law enforcement officers with regard to asking more specific VAWA questions? Could you speak to what shift in practice has been identified, and how might best practices be implemented and proliferated? Anyway, it was a question about law enforcement officers and the same-sex case.
Yeah, well, I mean, I think it really highlighted kind of the need for our law enforcement to have some training on best practices in dealing with a same-sex couple scenario and the communities associated with that, and having an understanding or sensitivity and trauma-informed training is really kind of what we're getting at with them, because it's very difficult, the VAWA sort of nuanced things aside, for law enforcement to go into those types of environments and one, not re-traumatize the victims, but at the same time make sure that they're doing the best that they can for in the interest of establishing a case and moving that forward. So there's definitely a fine line there in terms of their ability to respond to those types of situations. And there's plenty of training opportunities across the country for law enforcement that are being offered. And the trauma-informed training, I'm familiar with the Department of Justice offering that in certain instances where they can provide that type of training to law enforcement. And in particular to us, or specific to the VAWA component of it, based on the information that we had and the defense that the defendant used in that case, what types of questions, considering trauma-informed investigative practices, would we be able to ask to not re-victimize our victims, as well as gain valuable and necessary information for the case to move it forward? And that's what we're working with our law enforcement on, and we're still in the process of moving forward with the trauma-informed training or trauma-informed investigative practices to make sure that we can adequately respond to that type of scenario, as well as some training on the same-sex type scenarios. And so I think it just highlights the need to stay kind of up to date and be prepared for as many circumstances as possible.
Thanks so much, OJ. All right, here we have another question, and well, this is a question we've actually thought about a lot, so I'll take the answer from anyone. But what are the contempt powers of a tribal court against non-Indian defendants? And Steve Aycock isn't with us here today. He's our expert tribal court judge. But Steve has studied this question quite a bit, and at least the thought has been is that if a tribal court has the power to bring these defendants in front of them, they must have the power of contempt to enforce tribal court orders. What if they punch the bailiff? The tribal court judge, it seems inherent in their authority that they have to be able to maintain order in the courtroom. Virginia Davis, did you have any additional thoughts on that, or perhaps one of our judges about the contempt powers of a tribal court judge?
Yeah, I mean, the only thing I would say, is this is something that we have been talking a lot about with the intertribal working group of, the tribes that are working to implement VAWA. I think the question about contempt authority against non-Indians is broader than just this context, because tribes have non-Indians appearing in their court, not just as criminal defendants in a VAWA case, but in many other scenarios as well. And we're working on a publication or an analysis that provides some additional guidance on this in writing that I'm really looking forward to having out. But our thinking right now is basically what John said, that contempt power is best seen, both civil and contempt power is best seen as inherent in the court, and separate and apart from VAWA. We think that that the contempt power of tribal courts against non-Indians may be more robust than many of us who practice in this field have generally thought. I mean, of course, oftentimes the jurisdiction will set out some parameters around a court's contempt authority in their code. So to answer that question about any particular tribe, you would need to have information about any applicable tribal law in the area. The questioner was asking this, is the same questioner who asked about what do you do with someone who's not complying with their mandated batterer intervention treatment. So I wasn't sure if the two questions were related, but I think, in general, the mandated treatment is structured in a way that it doesn't require the court to use their contempt authority to deal with any failures to comply with that mandate. It's a probation violation. But with that, I will let either of the tribal judges chime in. But this question about contempt authority in a tribal court is one that a lot of folks have been thinking and talking about, and is more of an open legal question than some of the other things we've been talking about today.
This is Chief Judge Smith, and I'll just comment on that real quick. I've been waiting to be challenged on that, and I have contempted people. I've given a direct contempt at an arraignment of a non-Indian after he became belligerent and started throwing things around, and he sat 90 days for it. And then we did continue on with the arraignment after he had calmed down at a later time. But he did sit the 90 days for the contempt, and he did, file a habeas, and they had a hearing, and it went to the appellate court. And by the time that it had gone that far and came back, he was ready to change his plea. And so we never did get an answer on it from the appellate court, and he sat the time. And as far as the treatment, if we have a plea agreement in place and the offender is non-compliant, then we will go through the process of, we don't do a contempt, we go through the process, the civil process more so, I guess, of an order to show cause, bring him before the court, explain why we have not done these things, and then determine whether he's going to be revoked and just sit out the rest of the time that he's already had, memorialized in his plea agreement. That's all I have.
Thanks so much. Maybe I'll bring up another question I thought was an interesting question. This is actually a three-part question. Maybe the third part is the one that we'll focus on. Where should interested tribes start with implementation? the second question is, what advice would you give to tribes who are interested in implementing the law? And then the third question is, there's more than 500 tribes. I'm curious as to why only 18 tribes have implemented the Violence Against Women Act. I thought this one, the third question, of why only 18 tribes so far, maybe we ought to try to answer that. At least my experience with many tribes in implementing new laws, there are often a group of early adopters, tribes who are, they're trying out a new system, they're willing to try out new authorities. They often have to deal with a lot of issues. These tribes are, some of the most progressive. They have really good staff. They, like many of the staff you see here on this webinar, and they kind of break the barrier for other tribes. And then as time goes along, after 5 to 10 years or so, more and more tribes get into the program. I don't know why it goes that way, but you can see Indian Self-Determination Act and all kinds of federal laws affecting Indian tribes. It seems like there's usually kind of it kind of ramps up over a period of time, and then it's broadly adopted as tribes get more familiar with it. Does anyone else have any thoughts about, why are there only 18 tribes so far, and where do we see it going from here?
John, I'd add to that too that saying it's 18 out of 567, I think that it is now, is also not quite accurate, because not all tribes, there's a great diversity of Native nations. Not all tribes necessarily have their own tribal court system. So it's, and also not all tribes necessarily have land bases constituting Indian country over which they would actually have jurisdiction over some of these offenses. So it's really, it's really an 18 out of a different number that would really, be eligible for something like this, actually, making sense for their community. But other than that, I think I totally agree with what John said about it really taking some early adopters to sort of figure out the process, what some of the kinks are, and then, as I mentioned earlier, serve as really ambassadors to explain to other people in Indian country, how they can do this, how they can bring this to their community. And I think we've referenced it in passing previously, but haven't fully explained that there is an intertribal working group of all of the tribes who are currently implementing the law, who are in the process of trying to implement the law, or who are just thinking seriously about doing so. And that working group meets usually about twice a year, and it's really a time for everyone to come together and share best practices, give each other, advice and support about similar challenges, to think through all these complex legal issues that we've been discussing. And so I think also coming out of these first 5 years of implementation, the ITWIG, as we call it, has really been this amazing model of how something like this can really work at its best in Indian country, as not only something that tribes are doing alone as silos, but also that it really demonstrates how tribes can work together to figure out the best way to do something like this for their communities and then the rest of the country as a whole.
Hi, this is Judge Smith. I think in general, some of the issues that have been brought up to me and, questions being asked of Fort Peck is the cost. The cost of code revisions, the cost of hiring a public defender or possibly a judge if they don't have the law trained, to meet those requirements. The other barrier is incarceration. They don't have a facility of their own. And what does it take to contract, and how much is that going to cost? And some of the other issues on the very front side of it is how do they present this to the tribal government to get the tribal government to support them? And that seems we've done VAWA trainings in the past where we've had a separate component for the tribal legislative branch, and it's been a real poor turnout. They don't understand what it's about, and getting them on the same page is, I guess the way I would approach it is is taking it to them rather than them asking them to come to us. And educating the tribal council is one of the larger issues that I've seen a lot of tribes struggle with.
All right, thanks so much. Maybe just a couple more questions. Is there a difference in financial responsibility for the prosecution and detention for if the state is PL 280 or non-PL 280? That's a little bit of a complicated question. Public Law 280 allowed state governments to exercise jurisdiction on Indian reservations. It applies basically in 6 states, California, Alaska, and a few others. I won't go into all of them. The answer is basically yes, but not for the reason you think. In some of the states, in the PL 280 states like California and Alaska, the Bureau of Indian Affairs basically withdrew all the federal money back in the 1950s. So those tribes, although they have authority to prosecute, they don't get any federal funding, at least not from the Bureau of Indian Affairs. So they have, if they want to implement this law, their financial responsibilities are a lot greater. It's one of the real difficulties for PL 280 tribes is the lack of federal support. I don't know if you had anything to add to that one, Virginia, but it's another thing that we're continuing to work on is get more support for the PL 280 tribes.
It's funny, I had actually answered in the questions panel and had just said, no, there is no difference. But I agree with what you just said. I think I had interpreted the question slightly differently. That, whether you're in a public law 280 jurisdiction or not, the tribe is going to largely bear the costs of prosecuting and detaining the non-Indian using whatever resources are available to it. Sometimes that's federal money coming from the BIA or federal grants. Sometimes it's tribal funds. Another kind of wrinkle is, as John explained, what happens in the public law 280 jurisdictions and the fact that they have less access to federal funds for these kinds of purposes. The other thing that sometimes happens is for some tribes utilize the Bureau of Indian Affairs provides detention for them as a direct service, meaning that when they sentence an offender in a tribal jail, in a tribal court, that offender goes into a BIA facility, and so that can have that has different kind of cost, financial responsibility implications for the tribe versus the federal government in that scenario.
All right, thanks, Virginia. All right, maybe this will be the last question, and it's the Castleman question. Can you please tell me the reference that Elizabeth Reese made to the DV coming through the federal courts versus the VAWA definition she mentioned? How confused it was? Was there a specific case that brought ambiguity to the statutory definition? And yes, there was a specific case. It was called United States versus Castleman. That was a decision. It brought confusion because it's about a different federal statute. It was about if you commit a crime of domestic violence, and then you're no longer able to use a gun, and that federal statute is very specific. It has to involve, actual physical violence, and that is different from domestic violence, which is an undefined term in 25 U.S.C. 1304. There, it's just said violence committed. We've looked at it and believe the general definition of violence not only includes actual physical violence, but also includes threats of violence and also includes violence to property. And so it's created a lot of confusion, some open questions, but it seemed to me the tribes are getting it resolved. OJ, I know that your tribe has recently prosecuted a property crime as a violent crime. Is that correct?
Yeah, that was our third, our most recent jury trial that resulted in a conviction. It was the threat of violence through the use of the property and smashing stereos and directing violence towards the victim in a very aggressive and controlling manner, which was very consistent with general understanding of domestic violence dynamics of power and control. There was a lot more involved in that, but on its face, yeah, it's a crime against property involving violence towards an intimate partner, and that is that case. They made some post-conviction arguments to try to dive into that issue to look at the scope and limitations of that. And so far, we've been successful in upholding that conviction.
Thanks so much, OJ. It's tribes like yours, and thank you to all the participants, and really all the 18 tribes and everybody who's been participating in the Indian Tribal Work, the Intertribal Work Group on Domestic Violence. We really appreciate working all with you. I think we're at the end of our webinar, if this is correct, Elizabeth. And I'd like to thank all the participants in the American Bar Association. We really look forward to working with all of you and expanding the law in the next round for the VAWA 2018. Thanks very much, everybody.